Welcome everyone to this afternoon session of the Symposium on the Law and Politics of Unconstitutional Constitutional Amendment. We are immensely privileged to be joined this afternoon by four speakers who are truly experts in the field of constitutional law and in the field of comparative constitutional law in Asia. I could say a great many words concerning their respective backgrounds and scholarly contributions, but in the interests of preserving time for today's discussion, I will keep my introductions brief. Our speakers today are Professor Matthew Nelson, who I believe has recently moved, in contrast to the display we had up, to be a professor at the University of Melbourne. Professor Surya Deva, an associate professor at our sister institution, the City University of Hong Kong. Professor Ridwanul Haque, a professor at the University of Dhaka and a university fellow at Charles Darwin University. And our very own Professor Mara Malagodi, an assistant professor here at CUHK Law. So a few technical details to begin. If you have any questions during the talk, please send them in to me. My name, by the way, is Professor Christopher Roberts, but I'm using a university computer, so you'll see me as EP. I don't know what EP stands for, but that's my name for the purposes of this talk. So if you have any questions for any of the today's panelists, please use the chat function. You can send them to me, and I will then read them out during the question and answer session. Otherwise, those of you who are participants in this symposium, I believe you also have the ability to mute yourselves and speak up. So of course, take advantage of that privilege as well. The aim of this symposium is very much to generate dialogue and discussion. So please do send in any questions you might have. Okay, without further ado, let me hand over the floor to Professor Nelson.
Great, thank you. So I'm technically on leave at SOAS, but I'm also now here in Melbourne. So I'm kind of wearing two hats at the moment. And I'm gonna have to be a little bit brief because I have another Zoom call coming up in an hour. So I wanna hear as many of the papers as I can. But if you do have some questions and I'm not here at the very end, please send them anyway, because then I can look at them hopefully later and get back to you personally and so on. So my paper focuses on Pakistan. And I think in some ways, just to sort of frame it, it might be a slightly odd fit for the volume on unconstitutional constitutional amendments. First, because as Rehan pointed out right at the beginning of the day, the Supreme Court of Pakistan has never actually annulled a constitutional amendment, despite extensive engagement for decades. With India's so-called basic structure jurisprudence. Interestingly though, a little fact that is frequently underappreciated, one of India's own earliest basic structure judgments, known as IC Golaknath in 1967, actually cited an even earlier Pakistani case from 1963 that originated in what is now Bangladesh. And that Pakistani case, which referred to constitutional basic structure and essential features, was called Fazl Qadir Chaudhry. So just thought I'd throw that in for historical curiosity. The second reason my paper might be a slightly odd fit lies in the fact that unlike India, and as Dr. Son pointed out, referring to Professor Huang's arguments in Vietnam, basic structure jurisprudence in Pakistan does not stress the ways in which amendments might become unconstitutional when they alter or abrogate fundamental rights. That was emphasized in Indian cases, emphasized a case in Professor Huang's comments in Vietnam. But in Pakistan instead, there was a fellow named Abdullah Al-Mahmood who was active in Pakistan's first Constituent Assembly. And he emphasized, this is in the 1950s, that Pakistan's highest court should not test for fundamental rights, but rather for Islamic repugnancy. Not what is opposed to fundamental rights, but what is opposed to the core of the Constitution, Islam. Now in practice, Pakistan's first constitution, in 1956 explicitly stipulated that amendments would, quote, not be questioned in any court. Okay? And in 1985, this bar on judicial review of constitutional amendments was further reinforced with two clauses that were directly imported from India. In Pakistan, Article 239(5) stipulated that, quote, no amendment shall be called into question by any court. And then 239(6) went on to say that for the removal of doubt, there is no limitation whatsoever on the power of Parliament to amend any provisions of the Constitution. Now, these provisions, which were imported from India, were actually rejected by India's Supreme Court in a famous Supreme Court case, a basic structure case, known as Minerva Mills Limited. But in Pakistan, they still remain in place, even today, giving the Parliament ostensibly unlimited amending power. But the interesting thing is that these two provisions, ostensibly blocking any judicial review of constitutional amendments, these provisions have not prevented Pakistan's highest court from reviewing constitutional amendments for their compliance with the Constitution's Islamic provisions, just like Al-Mahmoud wanted. Even if in practice, the court has not yet actually struck down any amendment as repugnant to Islamic provisions. So they're reviewing them, but not striking them down for that reason quite yet. So given all of this background, my chapter doesn't actually examine the practice of annulling amendments in Pakistan. Instead, what I do is I use an account of sort of past judicial practice and then political events and a few interviews with retired Supreme Court Chief Justices, as well as key politicians involved in promulgating extremely important amendments. And I use that material to track the religious features of a debate about constitutional amendments and their amendability, constitutional amendments and the review of those amendments by the court. Specifically, I'm interested in a debate about whether the Supreme Court, or how the Supreme Court, or why the Supreme Court might consider annulling amendments seen as repugnant to Pakistan's constitutional Islamic provisions in the future. What does this emerging debate about possible unamendability owing to Islamic provisions sound like? So to sketch out this debate, I focus on a constitutional clause known as Article 62(1)(f). Okay, now Article 62(1)(f) was part of an eighth constitutional amendment introduced by a parliament that was convened in 1985 by the military dictatorship of General Zia-ul-Haq. So although a military dictatorship, he brought in a parliament under him, and that parliament had amending powers. Okay, so basically, I was sort of interested in Professor Ye's paper about efforts to constrain Taiwan's National Assembly. Because this Article 62(1)(f) basically outlines standards qualifying Pakistanis, both Muslim and non-Muslim, to serve as parliamentarians. And it requires these candidates for election effectively, and then sitting parliamentarians, to be, quote, amin. This means trustworthy, but trustworthy in a specific Quranic sense, following the terms of the Quran. Okay, and then in July 2017, the Supreme Court of Pakistan disqualified the Prime Minister Nawaz Sharif, precisely because he failed to qualify, according to the court, as amin, or trustworthy. Now this ignited a debate in Pakistan about possibly repealing Article 62(1)(f), possibly introducing an amendment to repeal this provision. Now, in India, basic structure jurisprudence has been used to remove elected legislators for failing to reflect forms of secularism as defined by India's Supreme Court. For instance, the case of S.R. Bomai in 1994. Now, Pakistan's Supreme Court has simply disqualified parliamentarians that are seen by the court as insufficiently amin in an Islamic sense. So if India's Supreme Court is removing parliamentarians or legislators at its state level because they're not sufficiently secular, Pakistan's Supreme Court is removing parliamentarians because they're not sufficiently amin. So my paper starts with an account of debates regarding the possibility of repealing Article 62(1)(f). But then alongside this, my paper considers a landmark Supreme Court judgment known as District Bar Association Rawalpindi. District Bar Association Rawalpindi in 2015. Now, to make a very long story short, basically this judgment emerged during a tumultuous period of judicial and political history. It emerged shortly after a later dictator named General Pervez Musharraf tried to sack the Supreme Court Chief Justice, Iftikhar Muhammad Chaudhry. Okay, now, this attempt to sack the Chief Justice was later rebuffed by the Supreme Court. You cannot sack the Chief Justice. But in due course, that judgment by the Supreme Court prompted Musharraf to declare a state of emergency. And in the state of emergency, scores of judges who were told to swear an oath of allegiance to the dictator, Musharraf, they simply resigned. Okay, so it's a crisis in the state. In the meantime, there was a nationwide lawyers' movement pressing to restore the Chief Justice. And that movement eventually pushed Musharraf himself to resign. And after several months more of protest, the Chief Justice was restored. In the wake of that tumult, there was another major constitutional amendment known as the 18th Amendment. Okay. Now, following Musharraf's dictatorship, this amendment basically sought to restore the power of Parliament. But in doing so, it took that idea one step further, and it gave parliamentarians more power to vet nominees for Superior Court judicial appointments. It gave Parliament some oversight over those appointments. In a preliminary review, very brief review of this 18th Amendment, Pakistan's Supreme Court urged Parliament to, quote, reconsider its encroachment on judicial independence. And it called judicial independence a salient feature of Pakistan's constitutional basic structure. Okay, so it's invoking all of the language of basic structure jurisprudence, and then it's just telling Parliament to reconsider this amendment. But what it does is it says the Parliament should avail powers within that amendment. Okay, and within the amendment, there's a power that allows Parliament to, quote, facilitate the amendment's implementation with new provisions and a simple parliamentary majority to pass them. Okay, so the court does not strike down this amendment. It simply says there's a provision in the Constitution that lets Parliament reconsider elements. Go ahead and do that. Now, at the same time, crucially, so-called backdoor channels involving the executive, we mean the military, also urged Parliament to reconsider its approach to judicial appointments. And in the end, Parliament accepted these recommendations and ensured judicial primacy vis-a-vis appointments. And they introduced a revised amendment known as the 19th Amendment. Okay, the 19th Amendment. All of this means that when a full court bench of 17 judges on the Supreme Court finally reviews the 18th and the 19th Amendment, in that case, District Bar Association Rawalpindi, this is after the Chief Justice had retired, the court does not strike down any part of either amendment. Instead, it upholds the 18th Amendment as revised by the 19th Amendment. Okay, so this is a story that has all the elements of noticing an unconstitutional constitutional amendment, but with no technical striking down of any portion of any amendment. Okay, so this is why we still see Pakistan as a country that has never actually deployed this power in the Supreme Court. Okay, effectively, backdoor channels obviated the need for any annulment. Okay, but this is the key point in that decision, District Bar Association Rawalpindi. The key point is that for the first time ever, a majority of the judges said that in the future, any amendment seen as violating, quote, the salient features of the Constitution, in this case, judicial independence, could be and should be annulled. Previously, this type of support for basic structure jurisprudence limited to a minority on the court. For the first time, a court's majority actually said that in the future, we should do this. In fact, Khurshid Ahmed, who's from an Islamist party known as the Jamaat-e-Islami, okay, I should note that he was a member of the parliamentary committee, both for the 18th and the 19th Amendment. Okay. He said, quote, the tone and temper of the judiciary under Chief Justice Chaudhry was such that we didn't want a clash. So even before the Supreme Court could annul anything we've done, Parliament ultimately, he said, conceded. Okay, so the judicial record does not indicate the full story about unconstitutional constitutional amendments as they are used conceptually and practically by the court. Okay. District Bar Association Rawalpindi focused on judicial appointments as a matter of judicial independence. Okay. But in their opinions, in that case, many of the justices discussed the Constitution's salient features more broadly. In particular, they discussed, crucially, whether Parliament could go so far as to amend, quote, constitutional provisions regarding an Islamic way of life, or Islam being the state religion, and specifically Pakistan's, quote, parliamentary form of government blended with Islamic provisions. Could those be revised? Now, former Chief Justice, Asif Saeed Khosa, he noted that, quote, Islam is not just a salient feature of the Constitution. It is a matter of faith transcending any constitutional dispensation. It sounds like he's very much in support of unamendable Islamic provisions. But then having said this, he turns immediately to Pakistan's constitutional history and he stresses actually Pakistan's unfettered amending power. He says, if at some future stage the people of this country have a change of heart or mind with respect to Islamic provisions, he says, the will of the people will have its way and the aspirations of yore may not be able to shackle it. Okay? In other words, again, the Supreme Court, according to Khosa, will not stand in the way of constitutional amendments, even regarding Islamic provisions. But again, in 2015, this notion of unfettered parliamentary power was the minority view in the final judgment. The majority held that what Khosa called the aspirations of yore, in this case, Islamic provisions, introduced by a dictator, accepted by their parliament, they could be read as an unamendable salient feature of Pakistan's, quote, parliamentary form of government blended with Islamic provisions. So in the chapter, what I do is I map out the debate amongst parliamentarians and amongst judges about, on the one hand, Pakistan's power to amend or repeal so-called Islamic provisions. And I focus on Article 62(1)(f). Okay, and I found, my interviews and so on, that most parties support a repeal of Article 62(1)(f). Right? This is the article that allows them to be disqualified and thrown out of parliament, including the prime minister. They support a repeal. But religious parties, very small share of parliamentary power, oppose repeal of that amendment. And then I look at judicial references to Pakistan's parliamentary form of government blended with Islamic provisions. And there's a judicial notion that this is an unamendable salient feature of Pakistan's constitution. Okay. Faced with the possibility of a constitutional amendment repealing Article 62(1)(f), read as an Islamic provision, no one I interviewed, not a single person, felt that moving forward, the Supreme Court would actually build on previously entrenched notions of parliamentary sovereignty vis-a-vis amendments. Article 239(5) and 239(6), giving unlimited powers of amendment, appeared dead. Instead, everyone focused on the Chief Justice of Pakistan, Chief Justice Chaudhry, and stressed that Supreme Court appeals to basic structure were now closely tied to the views of individual Supreme Court justices. So whereas basic structure jurisprudence in other jurisdictions might be tied to stable constitutional principles. Okay, and I think we heard something like that in the case of Taiwan, a notion of a constitutional principle. In other jurisdictions, we might see this basic structure jurisprudence being tied to the institutional priorities of the court, right? Defending judicial independence in the case of judicial appointments as an institutional priority for the court. But my respondents were not focused on overarching constitutional principles, and they were not focusing on overarching institutional priorities. My respondents saw basic structure jurisprudence tied to historically exceptional judicial personalities and their politically contingent patterns of judicial activism. Historically and politically patterns of judicial activism. In other words, my respondents basically, coming to the literature, strongly reinforced widespread concerns that basic structure jurisprudence itself is highly subjective, idiosyncratic, and personalized. In short, personalized forms of judicial power masquerading as constitutional basic structure principles. Okay? Now, some people at a particular juncture would be enthusiastic and applaud that because it serves shared interests. On other occasions, those very people would oppose that. Okay, including Supreme Court justices. Okay, one respondent says, quote, judicial activism is very much there, but it's had its ups and downs. This is from a leading senator. Actually, the chair of the Parliamentary Commission that drafted the 18th and 19th Amendments. That senator says, judicial activism is very much there, but it's had its ups and downs. He says, it depends on the temperament of the Chief Justice. And then a retired Supreme Court Chief Justice himself says, since the Chaudhry case, the judiciary has become more assertive. And he adds, a lot depends on the composition of the bench. He says, when it comes to religious issues in particular, it depends on individual judges. And as I think Professor Ye pointed out, it depends on, as this judge said, quote, the environment outside the courtroom. Everyone expected an attempt, everyone I spoke to, expected an attempt to repeal the Islamic qualifications in Article 62(1)(f). Everyone expected that to be met with widespread protests by religious activists defending Islam. Khurshid Ahmed from the Jamaat-e-Islami, in particular, expected, quote, an uproar. But in the end, few actually believed that these protests would derail parliamentarians' personal interest in repealing an article that seemed to allow individual judges to assess their trustworthiness. Individual politicians, irregardless of what the public thought, individual politicians might not want the judiciary to hold that sword of judging their trustworthiness over their heads. And they said, we'd like to see it go. Former Supreme... Oh, okay, I'm going to carry on. Former Supreme Court Chief Justice Khosa believed that Parliament was, quote, most unlikely to amend the Constitution for achieving something which may offend against an express Quranic command to be Amin. Politically, he said, referring to the Constitution's preamble, doing so would, quote, negate the raison d'etre of Pakistan's conception, creation, and existence. But in the end, Khosa still believed that if such an amendment challenging the Islamic elements of the preamble were to emerge, the Supreme Court would not be able to shackle it. Now, historically, Justice Khosa's opinion regarding parliamentary sovereignty was the majority opinion. But since 2015, the majority on the court appears to acquiesce to the judicial whims of individual judges. With reference to Islamic provisions as a salient feature, basically my chapter charts a shift from principles to personality. Debates regarding the power of judges to assess parliamentary standards of piety in Pakistan, I argue, illuminate the idiosyncratic religious side of global basic structure debates. We often hear about debates, institutional priorities, constitutional principles, a global, universal sort of conversation. Well, this is the personalized Islamic dimension of those debates. I think familiar controversies regarding unconstitutional constitutional amendments are also bound up with debates regarding not only democratic constitutionalism or authoritarian constitutionalism, but also, I suggest, modern Islamic constitutionalism. And I'll stop there.
Okay, thank you so much for that brilliant presentation, raising so many fascinating issues. I think in light of the fact that, as you mentioned, you're going to have to run, perhaps we should stop here and have a brief period of question and answer in case any of the other participants or members of the audience have any questions, so they can get them in while you're still here. So if you are a co-participant, please just unmute yourself and speak up at this time if you have any questions or thoughts on Professor Nelson's presentation. If you cannot unmute yourself, send your question to me in chat.
We can get things started. Thank you so much, Matt. That was fascinating. One observation and then a question. The observation is, it seems like Pakistan is just a few years behind India in terms of just judicial personality being everything, kind of a lack of precedent, a lack of structure. I mean, that's just the way in which the Indian Supreme Court decides opinions now. And I think that's been kind of well established. It's interesting that Pakistan seems to be lagging a little bit behind that, but now has come to that point. I was wondering if you thought, so one difference, I suppose, between the two countries is that in India, the BJP has really kind of put down roots and doesn't seem to be going anywhere. And they seem to have, in some ways, have captured the judiciary. Not entirely, right? Because there's the collegium and there's a few judges that are still quite independent, but eventually they will. There's good scholarship showing that retired justices suck up to the regime, so they get government jobs afterwards. There's a couple of recent chief justices do that. So that's, I think, happening. And so I wonder if you think that if that kind of situation happened in Pakistan, where there was kind of one party that dominated, as opposed to, as I understand Pakistan politics, it's still pretty splintered, and Imran Khan is here, and there's Nawaz Sharif, and there's the other one, the PPP, I think. But if there was more kind of one-party dominance, whether politicians would actually really like this system, where they could kind of just defer to their judges to disqualify minority parliamentarians on this basis of a mean, right? Because it sounds, the way you defined it, it seems like the religious garb is a very convenient way just for judges to get rid of parliamentarians they don't like. So if there was then an additional link where the ruling regime could have some kind of influence on the judges, it seems like that would be very convenient for the folks in power. And I wonder if the reason that hasn't happened is because the politics in Pakistan are so much more splintered. So anyway, I'm curious to hear your thoughts on that.
Okay, it's a great question. I mean, and it comes to, I think, the core of the symposium, which is about the underpinning politics of all of this. So two things. One is the trend towards political control over judiciaries, and whether that has been slowed by efforts within the judiciary to maintain some autonomy, particularly over appointments. And what's interesting is that case I described in Pakistan, where the parliament tried to have some control over appointments and the judiciary, with other help, pushed that back. That was happening at exactly the same time as debates about the same issue were happening in India with India's 99th Amendment. So watching those two processes of parliament seeking greater political control, the judiciary pushing that back, they are parallel experiences in India and Pakistan. What's interesting, however, is that now when we look at India, we wonder whether the judicial assertion of its control over appointments is going to be enough to maintain some autonomy. And the answer is maybe not. And I think that's relevant for this symposium in lots of contexts, because a lot of basic structure jurisprudence ends up being about separation of powers, independence of the judiciary, and things like that. And the judiciary stands up for its independence as part of the basic structure. Well, we saw that happen in both Pakistan and India. And maybe standing up for judicial independence when it comes to appointments is not enough to preserve judicial independence. And I think that's a lesson for us all to sort of watch. The other thing I would say is that your question was specifically about whether there's if there is a consolidation of power in one party, right? Maybe it's not that just the judges that would like power to throw out parliamentarians. Maybe it's opposition or government politicians that would like that power via the courts to throw out politicians they don't like. Okay, I think the best way to think about that in Pakistan is under Chief Justice Chaudhry. Okay, under Chief Justice Chaudhry, we had a military regime. Okay, and that military regime was absolutely trying to control the court, right? And you would imagine that obviously under the military regime, there is a government that some of whom are close to that military regime and some of whom are opponents of that military regime. But I think you can call it a consolidation and a centralization of power, generally. What you see during that context is a Supreme Court ferociously pushing back against the military regime, standing up for the opposition, okay, insisting that some of those opponents that the government wants to throw out should not be thrown out, and insisting that the judiciary alone should be the one to decide who gets thrown out and who shouldn't. In other words, trying to provide a buffer against some of that political opportunism. that might come with this notion of a mean, calling the other politicians less than a mean to throw them out. And the judiciary says, we're in charge of those decisions. Okay, so I think that there is something to be said for a politics that might like to exploit some of this jurisprudence, but the judiciary trying to insist that it is the gatekeeper for that process. And doing that pretty successfully in Pakistan, actually. So it's not just a puppet court, either of opportunist opposition politicians or of a very consolidated centralized government. So I think that's useful to keep in mind from the Pakistan case.
Okay, if there are any other members of the participants who would like, please.
Hi, Chris. Thanks, Matthew. It's a wonderful presentation, and I have a deep interest in Pakistani theory of unconstitutional and constitutional amendment, but I learned a lot from you. It's a new twist. I would just like to add one experience from Bangladesh with regard to the control of a judiciary from the executive, along with parliament. In Bangladesh case, also the vehicle to do this is an amendment of the constitution, and that's the 16th amendment in Bangladesh. But unlike India and Pakistan, this time the subject matter of control was not the appointment. Okay, we don't have any law for the appointment other than the constitutional provision in Bangladesh. It's about the removal of the judges. So in the original constitution, it was through the parliamentary process that a judge of the Supreme Court could be removed. What is the process right now in India? But in the meantime, the military dictator removed the process and imported a process from Pakistan. And that's the process of Supreme Judicial Council. Okay, so it's a collegium of the judges to remove a judge. Parliament is out. And by 16th amendment is very interesting amendment, because by 16th amendment, what Parliament did is the restoration of an original provision, 96, saying that we're not amending the constitution, but we're restoring an original provision. But the politics behind and underpinning the development shows that it's actually a retaliation from Parliament to judicial overreach by the courts vis-a-vis Parliament or the politics anyway. So this 16th amendment was challenged in the court that this is unconstitutional. But once again, this is the restoration of an exactly original provision that was there in 1972. This time, the court unanimously said that this is unconstitutional. Okay, but in the fight between the judiciary and Parliament, it's actually the executive that's winning, because it's the appellate division of the Supreme Court, the topmost tier of the Supreme Court, that said unanimously this is unconstitutional. However, in the meantime, the government did its own play, and it actually ousted the Chief Justice from the court. Sorry, not from the court, from the country. Now, the Chief Justice, who was the main author of the judgment, is in exile in Canada. And while the very judgment of the appellate division is under review, and there it remains pending for the last 5 years. So yes, it's very interesting when it comes to the typical three countries of South Asia with regard to either unconstitutional, constitutional amendment, or executive control of a judiciary. Sorry to long intervention for a long time. Thank you.
It was more of a comparative comment than a specific question, but I would also, I think I'll just reinforce some of your conclusion, which is that in these battles between the judiciary and the legislature, sometimes it's the executive that wins the most. So, you know, we'll look at comparatively across all these cases to see how that plays out. So I'll just leave it there rather than elaborate on the comparison. Thank you, Ridwan.
Okay, thanks so much. So I don't see any more questions in my chat. Perhaps in order to ensure we have full time for the remaining presentations and so forth, we'll leave it at that, but I'm glad we got to get a couple of questions to you while you're still here to answer them.
I'll stick around for another 20 minutes and then I'll have to duck away.
Okay, fantastic. So thanks again so much for the really fascinating presentation. Next, we have Professor Surya Deva. The floor is yours.
Thank you very much. And thank you also to Rehan and Son for organizing this excellent symposium and inviting me. So the paper that is still in my head, and my apologies for that, that I will be writing it in the next couple of weeks, is about constitutional politics over unconstitutional amendments, the Indian experience. And the key argument that I would like to build in this paper is that the basic structure doctrine is perhaps more relevant in today's time as compared to 1970s or 80s when it was developed in India, I would argue. And I think this is because of the concentration of powers, democratic deficits, dominance of one party, as Rehan was saying, populism, Hindu nationalism. And I think, of course, that my paper is going to focus on India, but I think we can see those trends in many other countries globally. So I would consider that the basic structure doctrine or limits, whatever we call it, on the power of amendment are more critical in today's time. Having said this, I would like to frame the basic structure doctrine as part of a wider framework of checks and balances in the constitutional scheme. And to ensure that this new role of this doctrine, I think we may need to revise and reorient some of the aspects of it. And I think that is what I will try to develop in this paper. For instance, I would like this doctrine to bind even the judiciary, because typically we see this doctrine that it is applicable to bind a legislation or a constitutional amendment, or it could potentially bind even the executive action. But I will argue that all three branches of the government should be bound by the basic structure doctrine under this part of checks and balances. I use 3 case studies, and because the focus is on politics, so I go beyond the cases and I call them case studies. And in fact, in 2 out of these 3 case studies, the judgments are not yet there. So I will touch upon that. In terms of the structure of the paper, I'll start with some preliminary remarks on 3 issues to situate my argument. Then I talk about briefly constitutional politics in India and these trends that are relevant in particular in the context of constitutional amendments or unconstitutional constitutional amendments. And then finally, I will go and talk about these 3 case studies. In terms of the initial 3 points, first question is, what is an amendment? To me, amendment is about change in the constitution, and there are diverse pathways. Of course, we have a formal constitutional amendment, but constitutions can also change by judicial interpretation. Constitutions can also change by a simple legislation. And I think my view is that for the purpose of the basic structure doctrine, we should construe the word amendment in a broad sense. We should look at, of course, both the form of it, but we should also look at the substance and the effect of a particular action. And I recently wrote a paper. If someone is interested, I'll be happy to share the link in the chat box afterwards about Hong Kong, where I have argued that the actions of the National People's Congress Standing Committee are unconstitutional because they breach the basic structure doctrine. And I think that is something we need to develop in Hong Kong as well. And the basic law is very explicit on that. So I think that is my first point about what should be an amendment. Now, the second question is, who decides what is constitutional? And of course, in liberal democracies, including in India, I think it's very well established that it has to be someone external to the decision maker. That is normally going to be the judiciary, if it is the legislative action or the executive action. But as I'm trying to articulate that even judicial interpretation should be subject to the doctrine of basic structure, then the question is, then who will decide in those particular cases that whether that particular judgment or interpretation is potentially in breach of the basic structure doctrine? And I think it's not a satisfactory solution in my view, but I think we have to rely on two things. One is the internal self-restraint. And I think it is easier in a way in the Indian Supreme Court because the judges are not there judges do not have life appointment. There are multiple judges. They don't sit together as a constitutional bench. So there could be a possibility of internal system of checks and balances. So it's not that one judge or 5 judges are going to be there for next 30 years. And they're going to sit together and they can do whatever they want. But I would also argue that the constitutional scholars, both scholars on Indian constitutional law, but also comparative law scholars, I think they would have to play a greater role and more proactive role in articulating that these are the cases or interpretations of the courts that are in breach of the basic structure doctrine. My third and the final point is about how do we situate or theorize the basic structure doctrine itself? And there's a lot of scholarship, and I will not touch upon everything, but I will just pick 2 or 3 strands of that. One, in the context of India, is that we can argue that, and Pratap Bhanu Mehta has argued that this is an instance of judicial supremacy. So we can see the basic structure doctrine as Supreme Court trying to take over everything in the country. And of course, that argument has also been made in relation to public interest litigation and judicial activism as such. The second possibility could be, we can rely on Sudhir Krishnaswamy's excellent book, that it is part of a shared sovereignty. We can see the basic structure doctrine as part of counter-majoritarian thesis. It is kind of a limitation, and we can't just in a democracy allow the majority to do anything and everything it wants to do, and it cannot really damage or destroy the Constitution in the name of the amendment. The third possibility could be that we see this as part of a constituent power. Conrad, the German scholar, very famously, who triggered this whole idea of basic structure doctrine in India, he argued about the constituent power and how it is different from the legislative power of the parliament. And of course, the excellent book of Yaniv, talking about that power could be seen as delegated power and trustees, so the power has to be limited. So I think these are a number of possibilities how we can explain, theorize, and situate the basic structure doctrine. As I suggested earlier, my thinking is that we should see this as part of checks and balances tool rather than as a Brahmastra. Brahmastra is a word from Indian mythology, which basically means that it is a weapon against which nothing else prevails. So Brahmastra is the most powerful weapon. So we should not see, in my view, the doctrine of basic structure as such a weapon in the hands of the courts that nothing else prevails against it. And whatever the court says the basic structure, and that's it, that is the end of the road. And we can't really go anything about it, because that, in my view, is highly problematic, because it defies the very idea of rule of law, it defies the very idea of separation of powers, it goes against the idea of democracy to some extent, and it might potentially open the door for social conflict and political conflict and potentially revolution. So I would like to balance the basic structure doctrine as part of checks and balances, because it embodies, in my view, a collective agreement of the society at a given point of time about certain core values. And these core values may be explicit, or these could be unconscious at a time when the Constitution is being drafted. But later on, because of certain situations, those unconscious core values may surface, and they have to be articulated as conscious core values. So I see it in this particular sense, and as I mentioned already, it should bind really all 3 branches of the government. Now, the next part of my paper, I would like to touch upon the aspect of the constitutional politics. Now, there has been a tremendous amount of discussion and interest about the politics in India. But what is it that the Indian Constitution talks about? Austin very famously argued about it's a social revolution. Constitutions are very transformative in nature. But I would say, in addition to that social transformative nature of the Constitution, the idea of Indian Constitution is trying to be very inclusive. It is trying to take on board everyone together. That's why it's a very long constitution. One of the explanations is that it provides, for instance, representation in parliament even to a very insignificant minority Anglo-Indian people. You know, so I think it is a very inclusive document. At least that was the intention when it was drafted. Things have changed dramatically under the Prime Minister Modi, but I think that was definitely the original intent in my view. And also a constitution which tries to strike a balance, the balance between fundamental rights and directive principles of state policy, the balance between the central government and the provincial government, the division of powers. So I think it strikes those multiple balances, and it makes that attempt to hold this very complex and diversified country together. Now, scholars like Bakshi and Rajiv Dhawan, they have written extensively in 70s and 80s about this politics. And it has unfolded in many sides. We have issues about affirmative action, for instance. There has been politics about public interest litigation, issues about religion and secularism. In Bomai case that Matthew highlighted is a key example of that debate and politics. The Ayodhya case more recently. There has been politics about the federal element, how the power should be divided, in particular the appointment of the governor in this for the states, and the use or perhaps misuse of Article 356 in the Constitution. So I think there are different sides. I would say though that in every side, the key element of this politics is different, perhaps. So we cannot really generalize and say that these are the elements of the constitutional politics in India, that they are relevant and prevalent or the dominant elements in every of those sides of politics. For the purpose of unconstitutional constitutional amendment, I will suggest that there are two strands which we should pay greater attention perhaps. One is the politics of supremacy. And this politics of supremacy has unfolded in India even just after the constitution was adopted in relation to right to property and this element of agrarian reforms that the land has to be redistributed to achieve social revolution. You know, it has also unfolded in the context of what I already mentioned just now, Article 356, where the central government can impose a president rule in the states. And the third example is judicial appointments, which I'm going to go very shortly. Now, in terms of the politics of legitimacy, the second strand, I think there is this constant struggle that whether the courts are doing something in a legitimate manner, especially if they are pronouncing the judgments which have serious policy implications, or they are entering into the domains of politics. Then there are serious issues about the politics and the legitimacy of those decisions. But of course, those legitimacy questions are also relevant in the context of parliament. Now, Indian parliament at this point of time is not very different, I would say, to the parliament of China, National People's Congress, because the opposition does not exist in practice. So the parliament is able to do whatever it wants to do. And because we have one party dominance at this point of time, and within that party also there is no democracy. So I think the interesting dynamics is that there is no check inside the party, there is no check from the opposition, there is no check from the media, and there are serious questions about the checks coming from the judiciary. So there are constant debates about this legitimacy and about their actions. And I think that is where we, the people of India, comes into picture. And that is where I would like to situate the protests that we have seen in India, in particular during the pre-COVID time, because now in the COVID era, we do not really have those protests unfolding, but I think those things did take place. And I think those people are asking legitimate questions. Now, let me quickly go to the case studies now. How much time do I have? Sorry, I lost track of my clock.
Denis, are you keeping time?
Okay.
Yes, there is still some time.
Still some time. How much time?
Yeah, 5 minutes.
5 minutes. Okay.
Oh, that's okay. That's not lots of time. But anyway, so let me quickly go through these case studies then. So the first one is about the judicial appointments. So to set the context, Article 124(2) of the Indian Constitution provides that the President will appoint the judges, the High Court and Supreme Court in consultation. So the word is consultation. And there are 4 Supreme Court key judgments on this, that what this word consultation means. And the first judgment, 1981, the court said the consultation means that there is no primacy of the judiciary, and the original intent was that the executive is going to appoint, and consultation is that you consult basically effectively, Of course, there has been instances of the executive in India misusing that power, and that's where the second judgment of 1993 created a collegium, which initially had only 3 people, Chief Justice of India and 2 other senior most judges. And then later on, that collegium in 1998 was expanded to make it to 5 judges. But basically, through the judgments, the Indian Supreme Court has created, which I will say is an amendment of Article 124. If you read the word consultation, it is there, but in effect, that word consultation has altogether different meaning. And the Indian Supreme Court has become self-appointed judiciary. And then came the 4th judgment, which was triggered by the 93rd Amendment of the Constitution, which tried to create a system of a National Judicial Appointment Commission with 6 members, and 3 of them are going to be from judiciary. And an act was also passed to implement this amendment. And I think that was declared unconstitutional, both the constitutional amendment as well as the act. And many people have written about it, including Rehan and Chintan Chandrachud and Gautam Bharti, and many scholars have commented critically on the judgments. Let me share a couple of points from my perspective, and then link it with the idea of politics, that how politics is relevant in this particular context. For me, this judicial supremacy here is problematic because it equates judicial independence with primacy element. I think it's not much novel here. But I think what I will argue is that it replaces one evil with another evil. The earlier evil was that the executive was misusing the power in terms of appointment. It was an opaque system. And now that evil has been replaced with another evil. So we have not really fixed any real systemic issues here. It also seems that the Supreme Court of India is confusing the 2 different concepts of independence and accountability. They feel somehow that any attempt of accountability is going to impinge upon the independence, and I disagree with that approach. Independence does not mean that judges could be gored and they can do whatever they want. Even judges have to be accountable, both in terms of how they decide cases, in terms of how they behave in public life, and so on and so forth. And I think that element is now missing significantly from the Indian Supreme Court. And I think because of this, I think the supremacy, of course, is there. And I would say they are exploiting this because of, if you look at the Indian politics, early 1990s onwards, there was a number of coalition governments at the central level. So after Mrs. Indira Gandhi, India had a lot of fractured mandates, and political parties at the center were not as strong. And I would say that provided the Supreme Court this opportunity to rewrite and completely take over Article 124 power to appointment. I think that is highly problematic. And I think, unfortunately, they also use as a justification that because the executive is misusing that power, that's why we have the legitimacy to do it. So I think that is the political side of it. Now, the second and the third case studies are more recent, and the cases are pending before the Supreme Court. There's no decision yet, and we do not know whether the decision will come out soon or it will take a couple of years. So second case is about Jammu and Kashmir, the autonomy that Jammu and Kashmir has under Article 370 of the Indian Constitution. What is very striking about this case study is that the executive, the President of India, did not use Article 368 to amend the Constitution. So Article 370 is intact. It is very much there on paper. But indirectly, they have used the Article 367 interpretation provision, to basically apply the Indian constitution to Jammu and Kashmir and overruled everything else which was basically there until 2019. And I think how they did it, I think in 360, let me briefly mention about 370. In Article 370, it talks about that the president has the power to issue an order, and under that order, it can apply any provision of the constitution, Indian constitution, to Jammu and Kashmir. But it must be based on the concurrence or recommendation of the Constituent Assembly of Jammu and Kashmir. Now, this Constituent Assembly is no longer there. It was dissolved in 1957. So what this order does, they amend Article 367, and they say that the Constituent Assembly in the Constitution, in particular Article 370, it basically means the Legislative Assembly. And at that particular point of time, there was no Legislative Assembly in Kashmir. So then the upper house of the central parliament behaves as the Legislative Assembly. There's also a provision about that you need to take the consent of the government of the state of Jammu and Kashmir. But because there was no government, rather it was the governor there. So then the governor, who is appointed by the president, becomes the government of the local. So I think basically, indirectly, and I think very creatively, they amend and take away the autonomy of Jammu and Kashmir without amending the constitution, without using 368 at all, because 368 is the power to amend the constitution. And that goes back to my earlier point that why we need to use the word amendment broadly for the purpose of the basic structure doctrine. Now, what implications this has, I think difficult to predict how the court will decide, but I very much doubt that they will be radically declaring all these orders and the acts unconstitutional. I doubt very much the Supreme Court will show that much spine, unfortunately. Now, there are political reasons in terms of the supremacy battle, the federal versus state angle here, which is there. Then there's an issue about the people of Jammu and Kashmir, whether they have any say in this political process when the elections take place later on, and how that will interplay with the central government and the politics there. Then there is an interesting argument, the economic argument, because the Indian government is saying that there is an economic argument for this integration. People of Jammu and Kashmir have been suffering from backwardness and exclusion because of 370. So I think there is this politics of legitimacy where the economic argument is used to justify misuse of constitutional powers or the politics. So I think that is there. Very quickly, just in one or two lines, so the third case study, which is about the Citizenship Amendment Act of 2019. In short, this amendment provides a faster route to certain people to become Indian citizen. What is problematic is that Muslims are excluded specifically because it talks about that Hindus, Sikhs, Jains, and so on and so forth. If they are from neighboring countries of Pakistan, Bangladesh, and Afghanistan, and they arrived in India by 31st of December 2014, that is the line, they would have a faster route to become Indian citizen. This amendment again is highly problematic. The case is pending. In my view, it is inconsistent with the basic structure doctrine on the count of both equality and secularism. But it reflects the politics in terms of the Hindu agenda and how under Modi, the India as a country and Indian government is behaving. And I think there were significant amount of protest, but the COVID pandemic was at the right time when the protest could not really continue. And I think that is something, again, to be seen in future, how this will unfold in the courts. So to conclude, as I mentioned at the outset, I see a greater role for the basic structure doctrine simply because we have a serious issue of democratic deficits, both in democratic countries, whether this is India or US or UK or anywhere else, as well as in non-democratic countries like the China or Hong Kong SAR. So we have a greater role, but we need to be more creative in articulating this doctrine and reinventing it to meet this new challenge, in my view. Thank you very much, and I look forward to any questions and comments.
Thank you so much, Professor Deva, for that inspiring talk, really getting at some broadening our imaginations about some of the underlying, I think, ideational frameworks we can use to think about unconstitutional, constitutional amendments. So since nobody else has to take off, we'll have all three of the remaining presentations, and then we'll go to a question and answer session. Again, if you do have any questions in the meantime, you can always send them in to me on the chat, and I will read them out at the end. So now our next presenter is Professor Vidwanul Hoque. So please, without further ado, Professor Hoque, the floor is yours. We'll just have to unmute.
Thank you, Chris. I think I have 25 minutes, and I try to be in time, within the time. Let me begin by giving a brief constitutional check or history on Bangladesh. Because I think that will add a perspective to all the listeners and scholars here. Bangladesh attained its independence from Pakistan in 1971, and the constitution was adopted in 1972, effective from 16th of December 1972. And it has been the same constitution that was adopted in 1972. Unlike Pakistan, we have only one constitution. However, like Pakistan, we have constitutional deviations, derailments. From 1975 to 1990, there was no democracy. It was absence of democracy. And during these 16 or 15 years, two military dictators ruled the country. And of those 16 years, 1990 inclusive, there were parliaments for some brief period, but those parliaments were under the military dictators or presidents. And so far, Bangladesh has enacted 17 constitutional amendments. Of those 17 constitutional amendments, the first 4 were made by the first parliament democratically elected after independence of Bangladesh, 1973. I mean, election was in 1973, first parliamentary election. Then constitutional amendment number 5 and 6 were during the first military dictator, Ziaur Rahman. So it's made by parliament, but under Ziaur Rahman military presidency. Then from 7 to 10th, another 4 amendments were during the second military dictator, General Asher, once again by parliament. Then 3 amendments by BNP, Bangladesh Nationalist Party. We have another major party, that's Awami League. The current ruling party is Awami League. So Bangladesh is basically a bipartisan country. 3 amendments, 11, 12, 13 were made by BNP. And, sorry, 4, 11, 12, 13, and 14 by BNP. Then the latest 3 were by Awami League regime, 15, 16, 17. And I have to specify one amendment, that's the 13th amendment. 13th amendment was made by BNP, but by a parliament that existed only for 2 weeks, 14 days. And as the Prime Minister told us, I mean, the then Prime Minister, the very election was held to make this only one amendment, 13th amendment, and the government was dissolved, parliament was dissolved. And this amendment is about the introduction of a special election time caretaker government system, not seen anywhere else in democracy. So the government is called caretaker government, was used to be in power for 3 months only during the election time to oversee a fair and free elections. Now, so after that introduction, let me go back to my paper. I won't give the formal introduction to the paper because the history is given then.
You've just come. Oh, there we go.
Sorry. Did you hear me up to the 13th amendment?
Yes, we only missed a few seconds.
Okay, fine. So let me now go to the substantive discussion of the paper. Well, the discourse or the discussion about the theory of unconstitutional constitutional amendment, or the possibility of amendment being unconstitutional, in fact began immediately after Bangladesh independence, or after the first parliament began to function. So in 1973, we got the first amendment, and in another 2 years, we got first 4 amendments. Of these first 4 amendments, 2 amendments are clearly unconstitutional. Amendment number 2 and amendment number 4. Amendment number 2 introduced executive detention without trial, for example. And amendment number 4 is in fact the most unconstitutional of all amendments so far. But it was made by the ruling party, which led the independence movement of Bangladesh. And this 4th amendment actually introduced a mini constitution. So it's not only an amendment, it's a constitutional replacement. I'm not going to discuss this amendment in my paper, in my chapter. This amendment transitioned Bangladesh from a parliamentary democracy to a one-party presidential democracy, actually autocratic democracy or autocracy. It's not democracy at all, because all the media or newspapers were banned, civil rights were postponed, and judicial review of fundamental rights was also postponed. And there was only one national party. All parties were banned. Unfortunately, very unfortunately, immediately after that amendment, the leader of the country, the founding leader of the country, the founder of the country was assassinated. And then began the long period of undemocracy or unconstitutionalism. So at that time, there were some debates, political basically, but because of the majoritarian politics, the discourse of, or the argument of unconstitutional constitutional amendment could not flourish that much. And as I have said, immediately after the 4th amendment, there was a change of regime, and the democracy was absent completely. So the discourse could not flourish actually. However, we often say that the genesis of the doctrine, or what is called basic structure doctrine in South Asia, is actually a case from Bangladesh in 1960s. It was 1963 case of Hogg versus Chaudhry, as Matthew Nelson briefly mentioned. I'll just cover this case a little bit because it has all the, facets of politics, of the politicking of unconstitutional constitutional amendment. This case was during the Pakistan regime. At that time, Bangladesh was part of Pakistan, and the case was initiated in the Dhaka High Court. So when the then President Ayub Khan amended the constitution by issuing a presidential order. So it's, I say it's amendment, but actually that's not the constitutional amendment, because President was given a power by the constitution to issue order to clarify, to add explanations or interpretations to the constitution. And that was the 1962 constitution. And it was actually written by Ayub Khan single-handedly by a famous Pakistani jurist. So it's his constitution. So what happened? The constitution chose a presidential form of government. And in one article, it was said that once a member of parliament is chosen as a minister, then the member will cease to be a member of parliament. So the seat will become vacant. There will be new election. And after that, the president, by an order, changed the implication of this provision of the constitution, saying that it will not function. It means a member of parliament can at the same time be a minister against the provision of the constitution as was enacted in 1962. Then Abdul Haq Chaudhry, a politician from Bangladesh, challenged the taking of oaths by 2 MPs and other MPs in the High Court of Dhaka. The Dhaka High Court said, yes, this is unconstitutional. The president cannot, by an order, change the meaning of the government, meaning feature of the government. And the phrases that the court used are very interesting. It said the basis of the constitution is the type of the government, the basis, very basis. And it also used the term cornerstone of the constitution. I mean, this separation of the executive from the legislature is a cornerstone of the arch of the constitution. Then the case was appealed to the Supreme Court, and the Pakistan Supreme Court said that this is unconstitutional. And Justice Cornelius used some phrases. Say, for example, he said, fundamental features of the Constitution, basic premises of the Constitution, something like this. So this constitution, this constitutional case from Pakistan period or from Dhaka High Court has the genesis and the beginning of the discourse of the doctrine of unconstitutional and constitutional amendment. One important aspect of this case is the time during when the court asserted its power. It was the military dictator in 1962. Although, I mean, there were some symptoms that the people were ready to revolt against that military dictator. And another important aspect of this case, which is very relevant for today, for constitutional politics in Pakistan as well as in Bangladesh, is the provision of judicial review. In that presidential order of Ayub Khan, it was said that no court will have power to challenge that presidential order. And interestingly, both the Dhaka High Court and the Supreme Court said, in a written constitution, it's ipso facto the judicial power to review constitutionality of any law, so it can be taken away. So that's the history. Now, let me go to the Bangladesh period. So the doctrine, the idea was clearly entrenched by the Bangladesh Supreme Court in 1989. So not too long after independence, and of course, I mean, it's a very young court because the court itself was unable to exercise its constitutional jurisdiction from 1975 down to 1987. So when the constitution was revived, within 2 years, it handed down this historic 8th Amendment decision, entrenching the doctrine of basic structure. The facts of the case, very briefly, the second military ruler diffused the Supreme Court's High Court division. Bangladesh Supreme Court was originally and also now composed of 2 divisions, integral, because it's a unitary state, unlike Pakistan and India. It's not federal. So on the top is the appellate division, and below that is the High Court division. Both are part of the Supreme Court. And in the Constitution, it was said that the seat of the Supreme Court will be only in Dhaka. But the sessions of the High Court can be held in other places by an order of the Chief Justice with pre-approval from the President. That's a different issue. But the second military ruler, by issuing military decrees before the 8th Amendment, by issuing military decrees, changed the constitutional provision, saying that the High Court division shall have 6 permanent benches outside of Dhaka. So it's altogether 7 benches. Then when the constitution was revived and the 8th Amendment was passed by Parliament to legalize the military amendment of the constitution, a local government leader challenged. He's not a politician, and definitely he has links with politics, but he's not a lawyer or a mainstream politician. A local government leader elected by the people's vote. But he had, connection with the regime, challenged the 8th Amendment. So after considering all the debates, the Supreme Court said that it's beyond the power of Parliament to amend the Constitution in a way that destroys its one of the basic structures or one of the basic features. Okay, and it's also a very elaborate decision in trying to determine which could be the basic features of the Constitution. So that's the story of simply entrenching the 8th Amendment decision. But there are politics, definitely. The biggest politics was the politics of people. Since particularly at the end of 1980s, since 86, the people were revolting against autocracy and the autocratic ruler, General Ashraf. And the lawyers in particular, who are based in Dhaka, they mounted a protracted revolution struggle, including street protests, including boycotting the court hearings against different changes or intrusions into judicial independence by the second military ruler. For example, one impact of the diffusion of the High Court division was the transfer of High Court division judges from one place to another. So whenever any judge came up with a slightly opposing decision, opposing to the regime, then the judge was to be transferred to a lesser known city or to a periphery. So all these factors actually fueled the legitimacy search for the judiciary. Even the court clearly noted in their judgment that the people's movement as well as the lawyers' movement all are important and all show that the government was not behaving democratically. However, what's important is that the judiciary acted or asserted its power during, even when the military dictator was in power, although in civil attire. It was in September 1989. But reading the body language of politics on the ground, the court could well imagine that the days of the military dictator were perhaps at the end. And exactly 1 year after this judgment, the military dictator fell, and there was a democratic transition from autocracy to democracy at the end of 1990. So in 1991, there was a parliamentary election, general election, and that transited Bangladesh to democracy. Then began a democratic period. In the meantime, I'll just briefly say a few words about the political trajectory before I pick up the other amendment for discussion. So in my discussion, I've got only 2 amendments, 8 and 15. Sorry, I forgot one thing, but I don't think that I can manage time, but I'll just discuss this in a line. The 8th Amendment had another part. It had got 2 parts. One is diffusion of the High Court division. The other one is the introduction of state religion, and that was Islam. So Bangladesh started its journey with secularism as founding principle. But in the meantime, the principle of secularism was taken away from the constitution, and the principle of trust in Allah was added as a constitutional principle. And by the 8th Amendment, Islam was introduced as state religion. So after that, some human rights activists challenged the state religion part of the 8th Amendment. And this challenge, or these challenges remained pending until 2016. In the meantime, the 15th Amendment that I'm going to discuss in a little while reintroduced secularism, but it did not do away with the state religion. So it means, and the amendment came in 2011. So it means Bangladesh constitution now have two provisions side by side. On one side, you have secularism, and on the other hand, you have state religion. And in the Supreme Court, you have a long-standing, long-pending case challenging the state religion. So the case was revived when Awami League came to power in 2009. And after 2011 amendment, the 15th amendment, the petition was changed anyway. The main argument on behalf of the state religion petitioners was that Islam as a state religion would be unconstitutional because secularism is the constitutional guiding principle. In 2016, after some initial willingness on the part of the court to hear the case, suddenly the court said the petitioners do not have local standing to challenge the constitutional amendment. So they abruptly dismissed the state religion amendment as a petition. So I'm not going to detail on that. Now let me begin with the 15th amendment. So as a way of introduction, so within this amendment, I'm actually discussing two in one because I can't avoid discussing 13th amendment that I have already introduced the society-specific or Bangladesh-specific caretaker government only for electoral time. The 15th amendment is a mixture of, is a mixed bag of both constitutional and unconstitutional amendments. But I here pick up two changes brought forth by 15th amendment. One is the abolition of the caretaker government system. And the other is the introduction of an eternity clause, Article 7B, saying that a long list of constitutional provisions, mentioning which are those provisions. Say, for example, provisions from 8 to 25, articles from 8 to 25, plus any other basic features of the Constitution or made unamendable by Parliament. So that came in 2011 through 15th Amendment. That's the second aspect I'm going to discuss within 15th Amendment. So let me take the first aspect of the abolition of caretaker government. So the caretaker government was abolished in 2011, but it has a background history. And the history is this. There was a case in 1999 challenging the introduction of caretaker government in the High Court Division. In 2005, the High Court Division said that caretaker government is not unconstitutional, is not undemocratic. Rather, it was a constitutional necessity to sustain, preserve, and culture democracy. So that was in 2005. So the case was by two practicing lawyers of the Supreme Court. Then immediately, the case was appealed to the Appellate Division. And then in Appellate Division, the case remained pending for long 6 years. And so 2005 to 2011, and suddenly, out of blow, the case was brought forth in the front line by the Supreme Court, especially the Chief Justice, and it was decided on 10th of May 2011. So you see, I'm going to discuss 15th Amendment that was enacted in 2011, September. And this judgment is from 10th of May 2011 from the Appellate Division of the Supreme Court. And it was a split decision, 4 versus 3. So it's a sharply split decision. Only 4 were saying that 13th Amendment is unconstitutional. Caretaker government system is unconstitutional. But the 3 judges are saying, no, this is not unconstitutional. They are concurring with the court below, the High Court Division. But what's the politics behind this decision is very nasty politics, and this is the backdoor channel, something like this, what Matthew Nelson said. But this time, this is not the army. So I guess there was a connection between politics and the judiciary, especially the Chief Justice who wrote the judgment. Firstly, because on 10th of May, it was only a short order of 3 sentences. And the Chief Justice retired on 18th of May in 8 days. So it seems that he expedited the hearing, he expedited the judgment. And such an important case on a constitutional structural issue, depending on the government form. So it was heard only for 9 days, and it was written, I mean, judgment was given just 8 days or 1 week before the Chief Justice's retirement. And of the 4 judges who subscribed to the Chief Justice's, I mean, or in the majority, all of them were made Chief Justices of Bangladesh, including the current Chief Justice. And from the minority, one is still on the appellate division, and of the 2, one retired, the other one was superseded and not made the Chief Justice of Bangladesh. And in the meantime, I'm sorry if I'm almost about to finish my paper or discussion, almost about there, but I beg your pardon if I cross the limit. Probably I'll take another 3 to 4 minutes maximum, beyond 25 minutes. So in the meantime, there is another constitutional amendment history or unconstitutional constitutional amendment history that fits into this politics of 15th Amendment, abolishing the caretaker government. It's about the 5th Amendment. In a private litigation, it's not a constitutional litigation. It's very, very interesting. It's a property litigation in a civil codes, but it went all the way up to the High Court division as an appeal. In that case, Justice Khairul Haq of the High Court division, who was the Chief Justice and who wrote the 13th Amendment judgment, the same judge, Justice Khairul Haq, a year before, in 2009 or 2010, declared the 5th Amendment unconstitutional. So what's the 5th Amendment? 5th Amendment is very interesting. 5th Amendment was the first amendment by the military dictator Ziaur Rahman. So it was a short amendment inserting just a paragraph into the Constitution saying that whatever had been done by the government since 1975 down to 1979 shall be deemed to have been done lawfully and within the Constitution. So the 5th Amendment actually legalized or constitutionalized the first military regime and all its rules, regulations, ordinances, and proclamations. So when the High Court Division declared and the Appellate Division endorsed the High Court Division judgment that 5th Amendment was unconstitutional. At that point, in 2011, the decision was in 2010, 5th Amendment decision. And in 2011, the Awami League government, the ruling party, thought that since military regime has been declared unconstitutional, so it's time to revive the lost provisions of the founding constitution of 1972. So it established a special committee to develop proposals for the 15th Amendment. And this special committee is special only in name. It's a parliamentary committee or parliamentarians because it excluded the major opposition, BNP. And also, it's for the first time in the country that this type of a committee has been formed to develop proposals for an amendment. Then it was developed it was formed in 2011 to consider the 15th Amendment proposals. So the special committee first did not have any proposal to abolish the caretaker government system. But in the meantime, the Supreme Court declared its 1 page or 1 paragraph short order that caretaker government system was unlawful. Even then, the special committee thought that they would wait until the final judgment of the court is released. But ultimately, the Prime Minister dictated the special committee that they should do something else. And in 3 months, so they started discussing the caretaker government issue in March 2011. and they submitted their final report on 6th of June 2011. And the committee, I don't know how or why they did so, they met the Prime Minister on 30th May. There's no necessity, no need to meet Prime Minister, because in the meantime, Prime Minister rather met the committee as a politician, as the president of Awami League. So anyway, so they, at the end, they suggested abolition of the caretaker government. And this is how the 15th Amendment came to abolish the caretaker government system. Now, the consequence is this. The parliament that abolished the caretaker government system was of an absolute majority. And the BNP had only around 40 to 45 seats in parliament, and they opposed the amendment. They did not join parliament, they rather boycotted the parliament. And as a consequence, what happened? They boycotted 2014 general elections. So 2014 general elections was a one-party election. And in the meantime, there was another, and the latest election in 2018. So BNP joined the election this time in 2018, but of the 306, they got only 5 seats. So 295 seats went to Awami League. But it's widely reported that it's a sham election. So what I argue is that since 2014 down to 2020 or until the next election, the Bangladesh democracy has made a U-turn. It's a democratic backsliding of a very grand scale. And there is no opposition in the parliament since 2014. It's only one government. And the opposition party was actually Electoral Alliance of the ruling party, Awami League. And they were notified as the opposition party. So that's the consequence of the abolition of 15th Amendment, caretaker government to 15th Amendment. The last part of 15th Amendment is the eternity clause. So it's 7B. So the politics behind this is that before introducing this eternity clause, the unamendability or entrenchment clause, the ruling party amended the constitution according to their wish, according to the way they wanted to amend the constitution. For example, in the constitution, I'm not saying this is a bad thing, but the problem is politics. In the constitution, the 15th Amendment inserted certain historical documents as constitutional documents, including the Declaration of Independence by the founding leader of the country, Bangabandhu Sheikh Mujibur Rahman. So that's the political declaration of independence given by Bangabandhu Sheikh Mujibur Rahman on 25th of March, 1971, when the War of Liberation began at midnight. Okay. However, this is Awami League. However, since BNP was established in 1970, late 70s, BNP was claiming that it's not Bangabandhu, it's rather their founding leader, General Ziaur Rahman, who declared Bangladesh as an independent nation. Okay, so there's a debate actually. So this time, 15th Amendment clearly inserted Bangabandhu's Declaration of Independence plus other documents, and also restored controversial, from the BNP point of view, fundamental principles of constitution, say for example secularism, say for example Bangladeshi nationalism. Then they amended to insert a long list of provisions as unamendable. So in the morning session, as Son mentioned about the unconstitutionalities, when the unamendability is on a large scale, that automatically becomes unconstitutional. So by this Article 7B, the Parliament has tied up the hands of the future generation of people or future parliaments, which is against established principle of constitutionalism. So the power belongs to the people, the constituent organ of the state, the people. So now they don't have power to amend their constitution over a long list of constitutional provisions. So now let me conclude in a few words. We have a protracted history of unconstitutional constitutional amendments. To be honest, of the 17 amendments, most of them are unconstitutional, with the exception of 2 amendments which are beyond any doubt constitutional. One is 12th Amendment, which was a politically consensus-driven amendment. So it actually came after a revolution in 1990 against autocracy. So all the parties sat together on a table and they decided that they should re-embrace the original parliamentary form of democracy. There was no dissent. There was an overwhelming political consensus. And just the parliament enacted the 12th Amendment Bill. That's the most democratic and constitutional. Another constitutional amendment is the 13th Amendment, introduced in the caretaker government system. Why am I saying so? It was introduced by a one-party parliament, and the parliament that existed only for 2 weeks. I'm saying this is one of the most constitutional amendment because there was another political consensus for the introduction of caretaker government. And it is the ruling party, Awami League, current ruling party, Awami League, that demanded caretaker government system and clearly said that without a caretaker government system, they won't join in elections under a party government. So the BNP introduced and enacted the 13th Amendment caretaker government system to live up to the demand of the ruling, the then opposition BNP. So in the politics of unconstitutional constitutional amendment, a number of factors and actors have actually interplayed, sometimes concertedly, sometimes without any harmony or antagonizing each other. And of those players, the judiciary played a very significant role. And apart from 8th Amendment, in all other amendment or annulment decisions, I think the judiciary has actually over-applied or abused or misused the doctrine of unconstitutional constitutional amendment. So far, the judiciary has annulled 4 amendments with finality, and one more amendment, 16th Amendment, is currently pending. So that's the overuse of basic structure doctrine of unconstitutional constitutional amendment. And from the part of the party politics, it seems that the trend to make an unconstitutional constitutional amendment is very obvious during a regime which lacks democratic legitimacy, like the current regime is elected, but it lacks its serious lacking of democratic legitimacy. And same as 8th Amendment, that was the military government. Although with the exception of 4th Amendment, that was by democratic government, but in the meantime, the government turned out undemocratic or autocratic without a constitutional amendment with the 4th Amendment. So that's all from my part. I look forward to having questions from the audience. Thank you very much.
Thank you so much, Professor Hoek, for that deeply informative talk. Now, it's my pleasure to give the floor over to our final presenter speaker for today, my colleague, Professor Malagodi. The floor is yours.
Thank you so much, Chris. Thank you so much, everyone, for being here. Sorry I missed the morning. I was on teaching duties. What I would like to talk about today is how do we assess the litigation in Nepal over the extension, the constitutionality of the extension of the terms of the first Constituent Assembly. So let me give you a little bit of background with respect to what I want to do. So the litigation in itself was hugely controversial. The first Constituent Assembly in Nepal operated between 2008 and 2012. The original term under Article 64 of the interim constitution was just 2 years term. So progressively what has happened is that the Constituent Assembly has extended its own term a number of times by amending the article in the interim constitution pertaining to the term. So a lot of litigation has been filed, a lot of partisan litigation. So I think, politically motivated lawyers affiliated with one political party or the other file litigation in the Supreme Court, asking the court to declare the constitutional amendments as unconstitutional. The court actually stopped short of doing that. And the two cases that I focused on in my paper, in my draft paper, are the last two. So the one in which the court kind of takes a stance and says, well, actually, this is the last amendment. The term of the Constituent Assembly is going to expire automatically in May 2012. So the Constituent Assembly really has to finish the drafting within that term. So that's the November 2011 decision, which caused outrage. There was a lot of pushback with respect to the decision, seeing the highest court of the land interfering with constitution-making activities. And then, of course, what happens just before the dissolution of the Constituent Assembly in May 2012, the government tables another amendment to the interim constitution, trying to extend the term for a further 3 months. And the Supreme Court, actually a single bench of the then Chief Justice, says, no, that would be contrary to our previous decision in November on the same matter. So the term will automatically expire. Otherwise, it would be unconstitutional to do so. So it's never an adjudication on the actual, it's not a finding of unconstitutionality of an actual amendment. It's a sort of constructive notice in November 2011, you cannot amend further. And then when an attempt is made to actually table a bill to amend the constitution further, the Supreme Court actually says, well, that would not be valid. The life of the Constituent Assembly finishes here. So that is the litigation that we're looking at. There were a few previous cases in which the Supreme Court had quite consistently ruled the previous amendments extending the term to be constitutional. So how do we interpret this? And my argument, which I think goes at the heart of the theme of the workshop, is that actually we cannot do that just by looking at the reasoning of the judges in these cases, but we have to take a much broader political view of the context. So what I would like to do today is to look at the constitutional context of Nepal post-1990. And I think we do that in 3 ways today. So first of all, we're looking in terms of time frame at developments after 1990. That I think is really the historical and constitutional frame that we need to keep in mind. First of all, we look at the development of the principle of constitutional supremacy in Nepal, again, post-1990, and more specifically at the position and the powers that the Supreme Court acquired after the second return to democracy in 1990. We look at the political context of post-2006, when the peace process begins after 10 years of a civil war. And we're looking not just, so this adjudication, this litigation that I'm centering my analysis on, I argue that can only be understood within the political context of post-conflict constitution making. Not just because of the context, but also in terms of the modality of constitution making. It is also so controversial because we're looking at a constituent assembly of all ways of making a constitution. We're looking at the modality that really epitomizes the idea of popular sovereignty, the highest form of constitution making. I'm kind of using Andrew Arato's conceptualization of post-sovereign constitution making here to think about that. And then the third element that I want to consider is what's the constitutional treatment of the amendment procedure in Nepal post-1990. And I think all these questions can only really be understood in a comparative perspective, especially with regard to amendments and the experiences of neighboring South Asian jurisdictions. And then, of course, there is the question of the aftermath. So again, it's not just about the constitutional and political context in which the litigation takes place, but it's also about, well, what happens? What are the consequences of the first Constituent Assembly failing quite dramatically, a second Constituent Assembly being elected over a year and a half after the demise of the first Constituent Assembly, and the result, which is an embattled constitutional settlement that remains in battle today. To make our story even more dramatic, of course, the issue with the litigation is that it was in the second case that essentially, in which the Supreme Court said, well, the first Constituent Assembly's life ends automatically at the end of the term of the, that the 11th Amendment of the Constitution extended, meaning May 2012. What happens immediately afterwards is that it was a single bench by the Chief Justice, Kilraj Regmi, who gets, immediately after the dissolution of the Constituent Assembly, gets handpicked to lead the cabinet. So you have the Chief Justice that adjudicating on both cases, becoming the, essentially the Prime Minister for a year and a half to lead the elections of the second, to lead the transition and organize the elections to the second Constituent Assembly. So can we really just make sense of this litigation by looking at questions of doctrine, or do we really have to engage also with very specific political concomitants of the Nepal case? So that's just an overview of the questions that have been troubling me. Let me go into a bit more detail with respect to what I wanted to do here. So what we see in 1990 is a sea change in terms of constitutional structures and powers of the judiciary in Nepal, mostly borrowed from India. The idea is to create a Supreme Court that encapsulates a lot of the powers that have been developed through adjudication in India. So just to give a couple examples, public interest litigation is recognized as one of the powers of the Supreme Court directly. There is a power of judicial review of legislation, which is quite forceful. And that the Supreme Court starts quite timidly, but very quickly becomes much more activist in a way that was unprecedented in the previous history. Also, you know, after 30 years of panchayat autocracy. So the Supreme Court becomes a very active constitutional actor in Nepal immediately after 1990. There are some of the cases that I refer to in my draft paper, the appointment, so adjudicating on the appointment of an ambassador, so on prerogative powers of the monarch. And then there is a very interesting set of cases adjudicated under the 1990 Constitution on the dissolution of their whole lower house of parliament, in which the court becomes really accused of taking a partisan's land, of supporting the dissolution or not supporting it, depending on which political parties have initiated the procedure. So these allegations of politicization with respect to the political question doctrine already is present in 1990. So what we see in other areas of constitutional adjudication, you also have an increasingly activist court. And that presents a set of challenges that develop also in the making of the interim constitution of 2007, immediately after the beginning of the peace process, and the way in which the judiciary is treated and the chapter on the judiciary is treated in the making of the current constitution promulgated in 2015. So there is also a lot of disagreement within Nepali constitution makers since 1990 about what's the appropriate role of the judges. And of course, this exponential increase in judicial activism becomes a theme also within the constitution making debates. So it has to be looked at in parallel. The second element is that I want to talk about is the political context of post-conflict constitution making, in what's a deeply divided society in which identity politics have really started to play a pivotal role, especially in the life of the first Constituent Assembly. The fact that the majority of the disagreements have to do with constitutional restructuring with respect to identity, federalism, quotas, recognition of historically marginalized groups, and so on. Also, if we look at the story of the first Constituent Assembly, what's happening? So you have a fragmented body with over 25 political parties represented, no party with an absolute majority, and you also have really active cross-party caucuses taking place. So women caucuses, Dalit caucuses, ethnic minorities caucuses, actually managing to find agreements beyond party lines. So the story of the Constituent Assembly is that by the time the first extension is granted in May 2010, actually the majority of the committee reports are ready. It's just the political leadership of the main political parties found no agreements over what had been prepared. So actually a substantive amount of work had been done, but not enough to consolidate the work of the committees into a draft that was palatable to all the political leadership. So what happens with the first? So I think it's a very different story between the original two terms and what follows. And I think one really needs to understand that political context and the working of the CA in that respect. So what happens after May 2010 with the first extension is that the controversial decisions are taken out of the Assembly. So the former Prime Minister created this high-level political committee, and you have all the controversial issues being kicked back to that committee, which is not even a Constituent Assembly committee. So it's something which is happening out there. And the extensions continue to happen. So you have quite a number of constitutional amendments from that point onward. So first extension, May 2010 is 1 year. You have another one of 3 months. You have a second one of 3 months. And then you have a further one, which is the last one of 6 months. So clearly, there is a pattern of extensions that do not lead to any significant move in terms of constitution making. What's happening in parallel is that constitution making is one of the two pillars of the peace process. The other pillar is arms management, and the agreement on arms management is actually only reached in April 2012. So constitution making is kind of on the back burner in terms of political urgency for the leaders. So in this situation of delays, where it's very clear that there is political impasse, especially then on the issue of federalism, that really becomes the main problem in Nepal. I did a couple of interviews with the former Chief Justice Kalyan Shrestha for Rayan's project on towering judges. And I asked about this case because that really became incredibly problematic for the reputation of the court. And what Kalyan Shrestha was one of the judges on the November 2011 decisions said was like, well, but you can't have a Constituent Assembly that renews its term indefinitely. And it was very clear that they had nothing to show for that extension. So what is the Supreme Court supposed to do after all those extensions have been granted, petitions keep coming? Isn't that also a legitimate position to have? So if you look at those kind of arguments, I can see where the judges are coming from in that kind of context. And then you look at another peculiarity, which is my third point, which is the constitutional treatment of amendments. So what's significant is that Nepal has had eternity clauses since 1990. But the interim constitution, which is the constitution under which this litigation takes place, does not contain any eternity clauses. So you have an eternity clause in 1990 that basically you have a special procedure, of course, and no amendments is allowed to infringe on the spirit of the preamble. That was a compromise between the Nepali Congress that wanted to preserve constitutional democracy and the king who wanted to preserve the monarchy. Left-wing political parties, and if you look at the records of the constitution making process at the time, were never supporting that position. So the idea was that just gives way too much power to the judges. it should be something for the political domain to sort out. So this position already, you can trace it historically back from 1990 already. Significantly also, not a single amendment to the 1990 Constitution ever took place. So you have an eternity clause, no amendments, but I think the language borrowed from the Indian developments of the basic structure kind of seeped into the constitutional culture in Nepal. So when you look at the judgments under the interim constitution, with respect to the amendability or further amendability of the interim constitution, especially because we're looking at Article 64, which is the term of the assembly. It's nothing to do with the procedure for amendment or restrictions on the substance of constitutional amendments. The language that is being used, and I think, you know, that's really an example of judicial dialogue across the region, the language of the basic structure appears in the judgment. And then you move on to look at what's happening then in the 2015 Constitution. The eternity clause comes back in, it's framed differently from 1990, and again, very little amendments, just one. First amendment immediately after promulgation. So that to me is quite an interesting story to look at in terms of the context. And I wanted to spend my last 5 minutes commenting on the aftermath. So at the time in which those two decisions were rendered, they were already deemed controversial. They were, especially by the more the left-wing political parties, the Maoists, the UML, the United Marxist-Leninist, talked about the judiciary overstepping its constitutional bounds and entering in not just into the political domain, but in the most sacred political domain, which is that of constituent power, looking at incursions into the work of the Constituent Assembly, directly elected, the most representative body in the history of Nepal. So very difficult to justify, I think, politically to begin with. And of course, what ensues makes the position of the court even worse. The nomination of Kilraj Regmi, the Chief Justice, to lead the interim cabinet, and of course, you know, if you look at the Nepali definition of the cabinet, is not called the cabinet in that period. It's a very long-winded expression. Talk about the interim council trying to avoid the use of any words pointing to the blatant breach of the doctrine of separation of powers. So you have an appointment, you have other two activist lawyers filing a lawsuit, basically deeming the appointment of the Chief Justice, who is also not resigned from his post. So he's retaining his judicial post. And the idea is that when I'm done with my executive job, I'm gonna go back on the bench. So hugely problematic, a lot of international backlash, petition filed in the Supreme Court, and the Supreme Court cowered. So they kept the petition pending and decided that petition on the appointment of Kilraj Regmi in 2016, when it was no longer a relevant question. So that had a disastrous impact on the reputation of the court. And I think the way in which the adjudication over the extension of the term of the assembly then was read in conjunction with the appointment of the Chief Justice to the top executive job in the country. So that, of course, was problematic. Secondly, what in my view was problematic as well was how that was reflected in the efforts of constitution makers in the second Constituent Assembly in framing the question of the judiciary. And I think the net result, and I don't think it's just this litigation, but I think this litigation really exposed the Supreme Court and the higher judiciary in Nepal to that kind of critique. Then the position became the judiciary in this country has to be contained. So if you look at the way in which the 2015 Constitution deals with the judiciary, it weakens the position in three ways. Creates a constitutional bench, which means massive backlog. So if you can only do judicial review of primary legislation in the constitutional bench with judges with a mandatory retirement age of 65 and a massive turnover of judges on the Supreme Court, it means that you have to refile every time you have a change in the constitutional bench composition of the judges, which means huge backlog. So that's historically in Nepal, it's been a successful combination of public interest litigation and judicial review of primary legislation that moved ahead a lot of the constitutional litigation. So effectively, that disempowers that avenue. Second is that they relaxed impeachment positions. So there have been already 2 attempts of impeaching justices, including the former Chief Justice, Sushila Karki. And third, they kept the controversial appointment position, retaining from the American model, the parliamentary hearing committee model, which is a duplication and essentially make sure that you have even more encroachment of the executive and the legislature on the appointment of judges. And we've seen a lot of politically motivated attempts. So that's the net result, I think, of what's been an ill-advised kind of litigation and position. But it's not just the litigation per se. I think it has to do with the context. And my final point is actually with the way in which the Supreme Court is viewed with respect to the outcome. The 2015 Constitution remains controversial. A lot of historically marginalized groups are not happy with that. It's problematic for the Madesi community in the South. And then, of course, the question is to what extent is the Supreme Court facilitated, whether it's fair or not, but I think the question in public domain remains. So those are the points I wanted to discuss. Thank you so much for your time.
Thank you so much, Professor Malagodi, for that fascinating presentation. Now, I believe we have about, that brings our presentations for today to a conclusion. I believe we have about half an hour for questions and answers. So once again, if you're unable to unmute yourself, send me your question or comment in the chat, and I will read it out. Otherwise, among the symposium participants, I think you can unmute yourselves or raise your hand in the video or in the chat function to let me know you have a question. So I open the floor to everyone. Do we have any other, does anyone else want to pose? Yes, Yaniv, please, and then Andrew. I believe you can unmute yourself, but if not. What's going on here?
Thank you very much. Thank you. Thank you, everyone. Hello. I apologize first for not attending the morning, but I hope to. I am reading all the papers, so I'm trying to keep up with things. Just that maybe, well, it's a focus question to Mara, but I think it's also a general question to the other participants, so feel free to answer. What is the value of protecting the spirit of the Constitution or the spirit of the Preamble, which is something so vague, so unclear, that can easily be manipulated by various political actors? Sometimes the Preamble protects so many conflicting values or principles. It seems almost useless. So I'm just wondering the political rationale behind. I mean, I can understand the normative argument, perhaps, but politically, what is it worth providing such a protection? Thank you.
Thanks, Yaniv. Protecting the spirit of the preamble is actually the formulation of the eternity clause only under the 1990 Constitution. And by reading the debates of the drafting commission, it was the preoccupation on the side of the king that because it recognized the existence of the monarchy, then you couldn't have had a Republican turn by amendment. So the idea was to entrench the institution of the monarchy. That was the rationale. And on the part of the Nepali Congress especially was the protection of constitutional democracy. So that was the agreement that was reached at the time. So that's kind of the technical bit. So if you look at the formulation under 2015, it's more to do with national integrity, national unity, and so on. So it's specific, it doesn't refer to the preamble. But I think, it's a question of substance, right? And the fact that, I think kind of going back to Professor Deva's comment about the role of the judiciary in these kind of questions, I think, there's always an element of what do they do with substance, which is always escaped just the procedural side. Those are my thoughts.
Then Anshu.
Right, thank you. This question is really for Mara, but I don't know if others might want to chip in. I was intrigued by one of the phrases, well, many of the phrases you used, Mara, but one in particular where you said the basic structure doctrine had seeped into the culture. And I was thinking that, I mean, if we're going to examine the politics of unconstitutional constitutional amendments, then should we not be looking a little more closely at how basic structure doctrine seeps into cultures? What I mean is, you know, who is doing this, and by what means are they doing it? Or is it simply that basic structure doctrine is lying around, you know, like some sort of natural resource waiting to be used by somebody that wants to pick it up? I rather doubt that, but I would like a little bit more enlightenment in terms of what actually is going on here. Thank you.
Thank you so much, Andrew, for your question. I think it's excellent. And actually, I picked that up in Matt's presentation on Pakistan, because he made a similar point, I think, about the language of the basic structure being used. So the way that I was thinking about that was in terms of South Asian constitutional culture and the fact that, for instance, in Nepal, Nepali judges, and I know for a fact, would read a lot of judgments, mostly from India, but also from Pakistan and Bangladesh, and they would be conversant in this kind of comparative analysis. I think it's also, I think, you know, what's the justification? I think to me in the reasoning, and I can, you know, that it's a good invitation to read the judgment even more closely with that lens, through that lens. But I think it's also the question of what kind of ammunitions do judges use, constitutional ammunitions do they use, when I think, you know, politically they know adjudicating a case like that puts them out on a limb. And I think basic structure doctrine probably is the best justification that can be used in those kind of circumstances. I'm just thinking from the top of my head, but I don't know if that resonates with you guys.
Professor Deva, I believe. First,
I mean, I wanted to add a brief comment to Yaniv's question, I think, and I will take India's preamble as an example to answer that question. For instance, the original preamble did not has the word secular, and it was inserted later on. So I think that is a concrete example how preamble could be used to interpret or articulate the substance of what is a basic structure of the Constitution. So I think there are different types of preamble. So let us say PRC Constitution has a preamble. I think that is not comparable to the preamble of Indian Constitution in many ways, because it is a Marxist and Leninist and another thoughts, and it's a very long preamble of political thoughts and all this, right? But I think so. I think it also depends upon what is basic structure. Is it the actual substance that you derive from the text of the Constitution, or the basic structure is certain overarching principles, right? And I think in my view, the preamble can be useful in either way. It can be used to articulate some overarching principles. And if there is a conflict, as you mentioned, or there could be competing goals, let us say the competing goal could be, I give another example from the Indian Constitution. Preamble says socialist. But India is not really a socialist country anymore. So how do we strike this balance between socialist, but if you look at the directive principles of state policy, they are also socialist element, but then there is also free market economy elements now, which are not there explicitly in the Constitution, right? Even right to property is not a fundamental right. So I think in those situations of competing interest, I think the preamble could provide the light to strike this balance and articulate that what should be the basic feature, because you are looking back, in my view. So let us say if the Supreme Court of India is articulating what are the basic structure in 2020, they are in a way reflecting back and also looking at the text and the current situation. So I think preamble could serve that purpose in my view. Thank you.
Professor Hoke, and then I think Rehan maybe wanted to jump in as well.
Thank you, Chris. This is just a short intervention from my point with regard to Yuanip's question, and I would like to add something to Professor Surya Deva's answer or explanation or comment. With regard to the unamendability of the spirit of the preamble or something like this, yeah, so definitely you can clearly see that it's politics and it's an open-ended term, text. I mean, so anything can fit into it because the Constitution's preamble is often a long preamble, 1 page, something different than statute's preamble. Having said that, if you come to, so with reference to Nepal, good that, I mean, that vague, opaque formulation of the text is gone over because it's in the interim constitution. The 2015 constitution doesn't have that. But if you come to Bangladesh, eternity clause, and in South Asia, there are only 2 countries which have eternity clause, Afghanistan and Bangladesh. Bangladesh is unique because we have both. We have basic structure doctrine at the hands of the judiciary, and we have eternity clause at the hands or nowhere in the constitution. Anyway, so in Article 7B, Bangladesh's eternity clause. So it starts with I mean, specifying provisions of the constitution. Say, for example, Article 8, an example. And also it makes the whole preamble unamendable. So you know, it's not only the spirit, it's the whole body of the preamble. You can't change even a single comma of preamble. And the point I wanted to make is, after, I mean, using these things, preamble, Article 8, Article 25, blah, 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 the ending few words are like this, and any other provision that is part of basic structure. So it's kind of spirit of the preamble type of formulation. So it's nothing but pure politics of amendment, something like that. And apart from that, I mean, just to add a few words to what Surya has mentioned, Bangladesh Constitution's preamble was elaborately discussed in the first basic structure doctrine case, 8th amendment case. And we see a lot of reliance on the preamble and the formulation of the words in preamble when the court developed basic structure doctrine. This is one thing. And secondly, what's unique in this preamble is the Constitution stipulates in clear terms that 4 principles are fundamental principles of the Constitution. So it's something different than fundamental principles of state policy or fundamental directive principles of state policy as are in Indian Constitution. So it says 4 principles: democracy, socialism, secularism, and nationalism are fundamental principles of the Constitution. So something like identity principles, identity of the state or identity of the Constitution. So the preamble could be that specific also. And in one of my writing, I argued that when basic structure doctrine was absent, I mean, before 1989, probably the framers of the Constitution wanted to mean that these 4 fundamental provisions of the Constitution or identity principles of the Constitution are unamendable. That was my personal argument based on the way the text of the preamble was designed. So thank you very much.
Okay, great, thanks. Let me give the floor to Rehan, who I believe had a question as well.
Thank you, Chris. I have a couple of questions. Great presentations, everyone, thank you. First, to Surya, I agreed with pretty much everything you said. So I just want to kind of ask you about something slightly different, which is, just trying to understand the Supreme Court as an institution, which I think is quite difficult, right? I mean, Nick Robinson has called it a polyvocal court, as you yourself said. It's multiple benches, different judges issuing different judgments at the same time on different topics. And so it seems like there are two ways maybe to understand it, or the trajectory of the court. One, I would say, is the traditional view, which is that, you know, the court kind of disappeared during the emergency, came back with a force in the 1980s. Then by the 1990s, there was a kind of neoliberal turn, and now who knows, right? It's probably the role of the court has kind of declined. There's another view, though, which I think Anuj Bhuwania and a few others have pushed, which is that the court has never been very good on civil and political rights, especially when it comes to the Northeast and Kashmir. And we should never expect much of it in that context anyway. And just the recent sort of silence on Kashmir with all the habeas corpus petitions, et cetera, kind of lends credence to that. And as you point out as well, with the National Citizens Register and the Citizenship Act, we'll see about the Citizenship Act, but it doesn't seem likely that they're going to do anything. And so how do we understand the basic structure doctrine in light of that? So is it then that the basic structure doctrine is just used for the court to defend its own turf, like with judicial appointments, or will it actually come down on the side of these important civil and political rights, which it historically, at least on Anuj's view, I think there's some validity to that, it hasn't done, especially in the kind of outer regions of the country. And then I have a question for Mara and Ridwan, which is that the Bangladesh and Nepal constitutions are interesting in that they put the basic structure doctrine in the text, right, which is an interesting move, and both have done so after courts have kind of used it, right? And in Bangladesh, it's after the courts have definitely used it, and in Nepal, it's in this strange way with the Constituent Assembly. And I wonder to what extent the impetus for that was to try to move this kind of discussion to the political realm, or was it to kind of buttress the court in using this doctrine more legitimately? Because it seems like it could be either one, right? So you could want to put the basic structure doctrine in the Constitution to make sure that courts enforce it, right? And the fact that it was just a judicial doctrine, maybe some judges would be uncomfortable. But you could also see them saying, well, no, we don't want the judges dealing with these issues. This can now just become a political issue. So I'm curious to know how that played out in both Nepal and Bangladesh.
So perhaps Professor Deva, if you want to respond first, and then.
Yeah, thanks, Ron. I think it's a difficult question to answer, but I will share my view. I believe that one difficulty with Indian Supreme Court, it is very incohesive and unprincipled court, in my view. I have critiqued its jurisprudence on capital punishment, for instance. I have found serious issues in terms of how the Indian Supreme Court has dealt with this concept of rarest of rare cases. I have critiqued it. I mean, it was more like a lottery. So if you are a you have been given a capital punishment, it really matters who is the judge in the Supreme Court hearing your review petition. And they are just not applying their mind.
Justice Pasayat was the one who gave a lot of death penalty, right?
I mean, there are many. I mean, so that is one example of the point I'm trying to make. The second is public interest litigation. More recently, you can see that how they address issues about bail. There's been recent controversy about this journalist from Republic TV, granted bail by the Supreme Court within 24 hours. But many other activists not given bail for many, many months. So I think there are those incohesive, unprincipled jurisprudence of the Supreme Court. So Supreme Court of India is praised quite a lot, but it is, rather than the institutional court, it is a personified court. So it is Bhagwati, it is Iyer, it is Verma, it is Kuldeep Singh, Green Bench, right? So these different personified court. And I think that is highly problematic as an institution. I will not go, though, to say that it has not been a good court or progressive court in terms of civil and political rights ever. I will not go that far, because it has definitely given some progressive judgments. It is stood for civil and political rights. The difficulty is, it is about the tides, high and low tide. And I think that creates it very difficult to judge the mood of the court, where it should be going and whether it is developing a cohesive jurisprudence on a particular area. Now, final point is about the basic structure. How does this doctrine fit in? I think I'll make a provocative point, and many scholars are here. We normally apply this doctrine in the context of an action. Can we apply this doctrine in case of an omission? Let us say judicial review is a basic structure of the Constitution. And you have a potentially unconstitutional legislation or executive policy taken, and the Supreme Court, for whatever reason, is sitting on it, and it is not acting to rule on its constitutionality. It's omission, in my view. And as I argued in my oral presentation, I will argue that the basic structure should bind all three branches of the government. So can we then argue that the Supreme Court, by not acting on those matters which are of significant importance, is breaching judicial review as a basic structure of the Constitution? So I think it's highly problematic that they are selectively using the basic structure. Basic structure should be developed as a tool to be used sparingly, of course, not in everyday case, but it is a tool that has a huge potential if we craft it and calibrate it to the new reality. I'll stop here. Thank you.
Mara and Ridwan, please.
Thank you, Rehan. Fantastic question. I mean, I myself was grappling with this question when I wrote a paper on eternity clause. Was the motive for the Parliament coming in 2011 to enter an eternity clause, and that's also very long. But it seems it definitely is not to take away the power of the judiciary vis-a-vis the basic structure doctrine, because the ruling party that introduced this eternity clause had derived the maximum benefits of the judicial application of basic structure doctrine. Because first, the doctrine was adopted in 1989 by the Supreme Court, then that ultimately led to the fall of autocracy, and that's how the democracy could return. This is one thing. And after that, the two amendments, the 5th and 7th amendments, were declared unconstitutional. And those amendments are amendments by the military dictators. So that also benefited the ruling Awami League. And the single most important amendment annulled by applying the basic structure doctrine is the 13th amendment, which actually benefited Awami League the most in the sense of, materializing the selfish political interest in abolishing caretaker government and to perpetuate in power. That's what's happening. So definitely they didn't have a motive to cling the power of the judiciary. But what they have actually, probably they thought that if this clause is there, then whoever comes in the next government, if the history is any record, since 1990 down to 2009, 2008, every single term was alternated between BNP and Awami League. So first it was BNP, then Awami League, then BNP, then Awami League, then BNP, then Awami League, until 2008. So whenever a new government, BNP or Awami League, comes to power, they amend the constitution. They amend the constitution, okay, to derive electoral advantage. So probably the idea was to debar the next incumbent political party from amending the constitution, particularly with reference to those provisions which ruling party Awami League have special love for. Say, for example, the secularism principle, the principle of socialism, and the principle of Bengali nationalism. Because all these principles are controverted by BNP. BNP doesn't believe in secularism, they don't believe in socialism, and they don't believe in Bengali nationalism. Rather, they believe in Bangladeshi nationalism. So all those of controversies. And on top of that, the Declaration of Independence, who made it? Since Awami League is saying is Bangabandhu, the founding leader, what BNP is saying is their founder who made Declaration of Independence. So I think that's the thing they wanted to, tie the hands of the next ruling party. Yeah. Thank you. I should mention a just important decision. So after the eternity clause was introduced, we got the 16th Amendment challenge in the court. So that was declared unconstitutional. Very interestingly, the then Chief Justice said, removal of judges through a parliamentary process is unconstitutional because it's against Article 7B. It's against the independence of the judiciary. And within the broad umbrella phrase of any other provision on basic structure of the Constitution, the court said is within any other provision of the basic structure. The Chief Justice, who was, expelled from Bangladesh to exile in Canada now. But one judge, Justice Iman Ali, who is still on the bench on appellate division, made a very interesting observation. In a paragraph, he said, he's also majority judge, this is an unanimous decision, but on 7B, he said, Article 7B has not been challenged before us. So we are not going to detail about it, detail on it. But in the next sentence, Justice Ali said, is open to question whether a parliament in present time can bind the hands of the next parliament or the future generation in amending the Constitution. So he did put a big question mark on the constitutionality of the eternity clause, although he said that that was not an issue before him to discuss. Thank you.
Sure, very quickly, as we're running out of time. Rayan, I agree with you, and Nepal shows an odd pattern, and I'm kind of wondering whether there is some kind of correlation between the existence of an eternity clause in the 1919 to 2015 constitutions and no political will to introduce amendments. So under 1990 constitution, not a single amendment bill was ever tabled. Under the current constitution, there is very little political will to amend. So just to give you an example, with respect to the implementing legislation for the fundamental rights sections, the 17 acts that were used, actually they were rushed through before the 3 years deadline that the Constitution imposes because the government didn't want to run the risk of having to amend the Constitution to extend that term. And I think because there are so many controversial provisions within the Constitution, I don't think the government wants to set a precedent. One. Two, I think, your question also pushes me back to Andrew's earlier question about, well, what about then this language? So on the one hand, you have it in the text of the Constitution itself, and you had it, when the litigation was adjudicated in 2011, 2012, it was already present since 1990, and plus there was a lot of comparative jurisprudence from South Asia. So I'm thinking along those two lines. Thank you.
Okay, thanks so much, everyone. I fear we've run up against our time limit, but thanks everyone thanks to the audience for the fantastic questions and comments.